Hi everyone, Harry here to talk about a really interesting brief, indeed a really interesting turn of events in the DC Circuit and its consideration now of Trump's appeal from Judge Chutkan's denial of his motion for immunity. All right, I've talked about this before. I don't think I have to go over that ground. Now it's in the DC Circuit, which is moving very quickly. Trump has to file another brief tomorrow. Oral argument is a week from tomorrow, and it's all happening. And now comes parachuting in a group, an amicus group. It's called the American Oversight. That's just a good guy sort of organization, of which there are scores in DC, and they're not a party. But there's a rule that sometimes people can file what's called an amicus brief. I'm just a friend of the court to point out something. You or I can't just do it for kicks. Yeah, you need to have a good reason when you're not a party. And the basic reason here, which is on the list, is there's an important point that nobody has considered. And there is an important point that nobody has considered. Indeed, as I look at it, could be a very important point, and I'm at pains to see why it isn't. Okay, so it's also, by the way, done. So American Oversight, they're known quantity, but also there are two law firms that are on it, Arnold and Porter and Kay Scholler are both big shot, well known, rich white collar law firms, and that itself will also arrest the court's attention for sure. Okay, there's a case. It turns out there's a unanimous case. It turns out there's a unanimous Supreme Court case. It turns out there's a unanimous Supreme Court case written by Justice Scalia, which seems to be very apropos here. And it has to do with whether you get a stay. In other words, or you could also say an interlocutory review to an immunity issue or the immunity issue that Trump is pressing. That's a lot of lawyer gobbledygook, but it is huge here because what it means is while Trump is trying to press his rights on appeal, for immunity, as we've been assuming, does the music stop? Does nothing go forward in the trial court? Meaning, does the trial date now scheduled for March just push back? Basically day for day. So if it's 2 months to work its way up to a minimum of 2 months of delay. So it's kind of everything here. Well, everything. If Trump wins on immunity, game over. And so that would really be everything, but I don't see it happening. I think both the DC Circuit and Supreme Court will hold against him. Indeed, if the DC Circuit does a really good, thorough appeal that says everything the Supreme Court thinks is necessary, you could even see the Supreme Court doing what's called a summary affirmance. Somebody petitions for review and they just boom, summarily affirm, and that's the same as deciding and the like. But it's been all about watching the clock. Now comes American Oversight and say, you know what? This assumption that everybody has when immunity motion, and it's a newfangled immunity claim. The Supreme Court hasn't addressed what happens to a criminal case against a former president. And you know what, court? Not only is it not necessary for you to grant a stay and for Judge Chutkan to stop the music, it's not permitted because you don't have jurisdiction. So what the hell? It's a real sort of eye opener, and at a minimum, the court's eyes will be opened, and the parties are going to have to say what they're thinking about it. So we've always been assuming, look, immunity is a right not to be tried in the first place, and not to be subject to the rigors of discovery in the first place. So you need to have an interlocutory appeal, because if you lose the holding and then you go through trial, there's really nothing to, your rights have been extinguished, and it does you little to get a legal ruling at the other side saying you had a right to immunity. You've gone through the trial. But now enter this Supreme Court case, which is called Midland Asphalt. And here is basically what it says. Um, it starts with the whole um, collateral review doctrine, which is the longstanding doctrine that everyone's thought has applied here. And it says, but maybe it doesn't. Not so fast. It's not enough. It's very important not to be confused between a doctrine that if you win, you don't go to trial. There's a lot of things like that. And in the Midland Asphalt case, it had to do with a certain kind of motion to dismiss for grand jury abuse. Between that on the one hand, as between a right, suing under a right that expressly provides that you don't have to go to trial. The court starts out, unanimous court, with all this stuff about how a collateral review is disfavored. You really want to get everything done at trial, and then the defendant can press all of their rights on appeal, and they can still have it decided. And what's the line they draw? So they state the same kind of three-part test, or really sort of set of considerations for getting for when you apply, when someone gets interlocutory review. But they take one of them and say it really has to be greatly narrowed to apply only when there's a constitutional prohibition or statutory that by its rights, very term says you don't have to go to trial. What's an example? The double jeopardy clause. The actual substantive right is not twice to be put in jeopardy. It's understood that you're in jeopardy when you're sitting in the defendant's chair and the jury, comes in and you're to sit in judgment on you. That's the actual violation. And so the question is, what about immunity? Is it a right not to be tried in the first place? Well, the test that the court gives is it expressed in a constitutional or statutory provision? And the executive immunity that we're talking about, as I say, it's never been established or even considered in the criminal context. But it has been actually, not for not going to trial, but in the Nixon case itself, which cast the huge shadow here, 9-0. The court says there's such a thing called executive immunity from, that's on the way to saying Nixon doesn't have it. And what's striking about it and important for this new brief is it's basically something that the court sort of infers or really creates out of the policies in constitutional structure. So they discern this principle of immunity. In that sense, you could say, now we're really right at the where the rubber meets the road on this American Oversight brief. On the one hand, you could say the courts discerned a right not to be they go through a lot of things. It's not exactly the trial for the at least someone who's already held presidential office, but there's all kinds of policies like not having a president while in office have to think twice about liability, and other things about the separation of powers. It seems to me, if you're taking seriously the notion that there's a constitutional or statutory prohibition that by its terms says you can't be tried this executive branch immunity, basically judicially created, basically about certain constitutional values, but only sort of indirectly about not having a former president go through the rigors of trial and discovery. It's at least as an initial instinct, and this whole case will be about really fleshing out what the court means. But it feels to me like it falls on the other side of the line, not an express constitutional or statutory provision. Now, can Trump argue? Could a court hold? It really is, because it's not expressed in the Constitution, but it's a principle we derive from the Constitution, and it's a constitutional moment. And it, the bottom line is to keep presidents from being tried. That's the remedy anyway. Yeah, I could see that. But if you read Midland Asphalt, it's really serious about the distinction between black and white prohibition on trial, and that's the whole point, like double jeopardy, and other situations in which if you win, you don't have to stand trial. And those situations, by and large, don't get you a stay. All right, and why is this? This is, I know we're going, way deep in a legal rabbit hole, but jump out for a second and look at what they're saying. What they're saying is the Court of Appeals had no jurisdiction over this case. This claim has to stay with Chutkan. And what does that mean? That means no stay. That means the proper thing for the Court of Appeals to do is just dismiss for want of jurisdiction. They don't have it yet. They have to wait until it's gone through trial. And if they do that, and the court might or might not take cert, it would mean that we are back in Judge Chutkan's case courtroom, and this, sort of interrupted period of what's it been so far, a couple weeks, stops. And with it, Trump's greatest hope for delay. So now there's really not an obvious one anymore that lets him get out of Chutkan's clutches, and it's just her managing the different things and roadblocks and possible pretrial claims, mainly far-fetched, and she's shown herself really strong about doing those on schedule and not having things slip. So if this prevails, we're talking about a trial in late March, and it puts an end to all the considerations of how much delay Trump could wring out of this principle, because it gives him the right to an interlocutory review. Maybe it doesn't. Maybe it isn't even permissible. That is what's hugely important and interesting about this just filed brief. The court, as I've said, will be hearing oral argument a week from tomorrow. You can bet that they're going to ask, maybe even in advance and in briefing, the Trump and the U.S., what is your position on this claim that the Midland Asphalt case deprives us of jurisdiction in the first place, which now they have to consider. You always have to think about a jurisdictional bar, and they're going to have to resolve it one way or another. So this is going to be playing out soon and could be huge. Could fizzle. It's new ground, and I recognize my analysis, might be a little strict, but strict reading of a Supreme Court opinion, that's not a bad thing. And at a minimum, it's a really important development. So we'll follow it very closely and see in particular whether the Court of Appeals, before even the oral argument a week from tomorrow, ask the parties for their opinions, and then what the Department of Justice in particular says. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.